You paid for a service, but you didn't get what was promised. Now, this is an unfortunate situation. However, it's important to realize that sometimes dissatisfaction doesn't always mean a breach of contract. Work can still be compliant with a contract and not be up to the standards that you may have been expecting or hoping for. A breach of contract occurs when one party agrees to perform an obligation but fails to perform that obligation, and that obligation causes you damages. What people need to consider before filing a suit for a breach of contract is whether there was a contract to begin with, whether the other party reached that contract, and whether you were damaged. Now, contracts can be either written or verbal, so you can establish a contract just based on an oral promise or that quick text message that was sent. Whether there was a breach could mean that there was a delay in performance, especially if there was a time limit to have that performance completed, whether the other party didn't provide what was actually promised and substituted for something that wasn't of the same value, or whether they just didn't do the work at all. Damages can be easy to prove. You could, if you were, for example, having a house and there were delays in having the house, you would have damages with having the additional rental that you had to keep before you could move into your new home. If you were promised some kind of work and that work was never done, then you had to find someone else to complete it. That would also be a way of proving damages. My name is Julie Oshesky. If you think you have a breach of contract claim, give us a call at Venezia Associates.